So the matter before the court is Kennebec 23419, Aubrey Armstrong versus the State of Maine. I see counsel are present. I'm assuming ready to proceed. I'm going to ask you to please introduce yourselves for the record by saying your name together with the party that you represent, starting with the appellant.
Good morning, Your Honor. Michelle King for the appellant, Aubrey Armstrong.
Katie Sibley, State of Maine appellee.
Thank you. We are being streamed live on the web, both by audio and with video. And Attorney King, if you are ready to proceed, we'd be happy to take your argument, and you're welcome to bring the water up to the podium.
Thank you so much, Your Honor. Good morning. May it please the court. Michelle King again for Aubrey Armstrong. The law surrounding the issue of equitable tolling is fairly straightforward. It's a case-by-case analysis of two factors: whether the petitioner has been diligently pursuing his rights and whether there is some extraordinary circumstance that stood in his way of a timely filing. The diligence required is only reasonable diligence, not maximum feasible diligence. This case, Your Honors, is a complete mess. Mr. Armstrong filed a petition for post-conviction review on April 10th, 2023. What happened thereafter has denied Mr. Armstrong the assistance of counsel to properly frame his post-conviction claims and has resulted in no meaningful review of any of those claims. In his initial petition, Mr. Armstrong requested appointed counsel to help him formulate whatever claims he may have in his post-conviction petition. That petition was summarily denied on May 8th, 2023, without appointment of counsel. While summary dismissal is contemplated under Rule 70, this court has also cautioned that it's best practice for trial courts to appoint counsel so that worthy claims of post-conviction review are not lost. Mr. Armstrong filed a motion for reconsideration of the denied PCR, but it was never docketed in the lower court. However, we do know that that motion was received because it was denied on July 13th, 2023. Mr. Armstrong also filed a motion to extend time for an appeal of the denied petition for post-conviction review. That motion was also denied. In doing so, the lower court said that it had no authority to extend the time for filing a notice of appeal, that it was this court who had the only authority to do that. That ruling was erroneous because under Appellate Rule 2B, the trial court may extend such a time. While all of this was happening, Mr. Armstrong attempted to file a second PCR, but could not do so before the deadline. It's a sworn petition. It needs to be notarized, and Mr. Armstrong was unable to get it notarized before the deadline. That second sworn PCR was filed 1 week after the deadline of June 7th, 2023 to file an amended PCR. This case, I would suggest to you, is directly on point with the case of Ramos. In that case, a PCR was filed 15 days after the deadline. The court addressed both factors of equitable tolling and determined that Mr. Ramos had diligently pursued his claims and that there was an extraordinary circumstance that prevented him from filing his petition on time. In Ramos, the court said that desire and feasibility are not the same. Mr. Ramos desired to file his habeas corpus petition earlier.
I see the green is on. Can I just ask you a total side issue here out of curiosity? You said the petition must be notarized.
Yes, Your Honor.
Is that in statute or rule? I'm just questioning where that appears, the requirement.
I believe it's by statute, Your Honor.
We're going to suggest to you that it's actually not in the statute. However, I'm going to suggest to you as well that Rule 67 requires that the petitioner use the court form.
Thank you, Your Honor. I stand corrected.
And the court form has a notary portion.
It does, Your Honor. And,
right.
and as a side note, I've had them rejected for failing to be notarized.
Gotcha.
So
Thank you.
It's upheld.
Didn't mean to interrupt your train of thought.
No, that's fine, Your Honor.
Could-
With respect to the claim that he was denied appointed counsel in a timely fashion, he filed his first petition on April 10th.
Yes, Your Honor.
The court acted on that petition within 4 weeks.
Yes, by May, yes, it did, Your Honor. I might add, without an opposition by the state. So it was summarily denied, no opposition by the state, no appointment of counsel.
But what I'm trying to get at is, what's the essence of the delay claim here for appointment of counsel? Is it that counsel should have been appointed before April 10th to help him prepare that petition? Or is it that once the petition was filed, counsel wasn't appointed in a timely fashion?
It's the latter, Your Honor. I would suggest to you, certainly the court would not know to appoint counsel before a petition has been filed.
Right.
But in this case, Mr. Armstrong specifically requested that counsel be appointed to help him file an amended PCR claim because he was unable to ascertain
But
what
under the
claims he may have.
PCR rules, I mean, the procedure that was followed here, i.e. a review for summary dismissal, which is essentially like a 12B6 review, occurs before the appointment of counsel, does it not?
It does, Your Honor, and as I started out saying, the rule does contemplate that that's allowed. However, again, in a number of cases, this court has said, Smith and McEachern in particular, that the best course of action when a PCR claim comes in is to appoint counsel and allow the petitioner to have counsel help them file an amended petition.
Do you agree that the first petition that was filed on April 10th, did not on its face raise a cognizable claim for PCR?
Yes, I do, Your Honor.
And under Rule 70, of course, it is standard once counsel is appointed to have the petition amended.
It is standard to have the petition amended.
Should the second petition that was filed have been considered an amendment to the first petition rather than a new petition?
It could be labeled an amendment, Your Honor, but it was also done without counsel. So again, a number of times during that process in his motion for reconsideration, he again asked for appointed counsel.
Well, can I go to the motion for reconsideration? I think you filed a copy of a motion for reconsideration, and as you indicated, there was no motion for separate motion for reconsideration docketed in the first PCR file. I've reviewed the original file. It's not only not docketed, there is none there. There is only the motion for enlargement of time that also sort of references reconsideration.
Correct, Your Honor. So that's part of why I suggested this case is a mess. The lower court clearly believed that there was a motion for reconsideration in play because if you look at the record,
well, was it just considering that the motion for enlargement of time was also a motion for reconsideration?
I would suggest not, Your Honor. There's a separate paragraph that addresses the motion for reconsideration in addition to the motion to extend time for filing an appeal.
Well,
separately
he had
discussed.
filed a letter. He filed three things on that initial submission. He filed a letter requesting reconsideration. He filed a cover letter, and the cover letter to the motion for extension of time or enlargement of time. So I think my reading of the docket record is the clerk looked at the letter and docketed it as motion, other motion. And that's what the judge acted on in his May 8th order. But I want to turn to the second petition. Mr. Armstrong was able to effectively identify cognizable ground in his second petition without the assistance of counsel, was he not? He identified ineffective assistance of counsel several times. Of course, all of that relates not to the preparation of his PCR, but to his trial and an appeal from the trial. But my point is, after the deadline, he files a second petition, and we have said you only get one bite at the apple on PCRs. That second petition identified cognizable grounds. Why couldn't he have identified cognizable grounds prior to the expiration of the deadline, his first petition?
Yes, Your Honor. I know that there's a lot of things that happened in this case that aren't in the record. I could try to tell you what I understand, but it's not in the record. And I think that's part of the problem is that the way this case came about and Mr. Armstrong, on a number of occasions, at least in his memorandum to this court, asserted that he tried to have conversations with counsel, he tried to get help, and so in between the period of filing his first PCR and his second PCR, although he was not appointed counsel, I can't say whether he received somehow some advice from somebody else. I can't say.
But
It's
can I
simply
address
not-
the issue
It's simply
of-
not in the record.
Is the equitable tolling, even if we were to agree with you as a general principle that equitable tolling could apply, does the petition have to at least have on its face some grounds that would raise the issue of equitable tolling? I think it's the state's position that it doesn't raise that at all. And it doesn't. It doesn't say anything in the petition. It's only on this appeal that there have been some suggestions made as to why it should be told. Isn't that essentially waived at that point then if it's not raised in the petition?
Well, again, Your Honor, I know that we try to hold pro se litigants to the same standard as lawyers, but I would suggest to you that requiring a pro se litigant who has limited reading capabilities of understanding the concept of equitable tolling, or
If
that
he
it's
could have
even,
just said, it took me a while because I couldn't get it notarized.
that,
Excuse
Well-
it, he has a way, he certainly does a lot of this. I mean, you know, excuse it being late, I couldn't get a notary.
well, again, Your Honor, there's information that's not in the record. I have affidavits from Mr. Armstrong that are not in the record that say exactly that.
Do we need
But,
to
what-
remand this to the trial court to make a record? I mean, we're struggling with what is and what isn't here. Do we need to remand this to
I would
get a full
suggest that
record?
that's the exact remedy here, Your Honor. You remand it, you allow Mr. Armstrong to have counsel who can help him through this process, make the record as to whether or not there's equitable tolling or not, and then we can at least have a meaningful discussion.
But the grounds that you've articulated throughout this argument have been basically he didn't know what he was doing because he didn't have a lawyer. That's not a ground for equitable tolling, is it?
That's not exactly the argument I'm making, Your Honor. For due diligence, the argument I'm making is he has filed a number of things. They've been unsuccessful, but
Well,
from
the time crunch here is due to the fact he didn't file his first petition until 10 months into his 12-month deadline.
Correct, Your Honor, but again, the record in front of you is devoid of the fact, although if you consider the memorandum that he filed with this court that talked about the numerous times he tried to reach out to his attorneys, tried to reach out to courts, tried to get the trial court record, tried to get his documents from his attorneys, all of those things, which he did put in his memorandum to this court, suggests that from essentially 2 months after the point in which his conviction was affirmed on appeal, he did start that
Do
process.
you agree that we apply the same standard for equitable tolling as the federal courts apply for habeases?
I do, Your Honor, and that's why I've cited a number of federal cases.
And do you agree that the ordinary delays of being in restraint in prison are not grounds for equitable tolling?
I do, Your Honor, but I would suggest that having a caseworker who can't notarize a document for 2 weeks is not the ordinary course that's conducted in a business.
So there's something, he shouldn't have known that it takes a long time to get a notary when you're in prison?
I think a 2-week delay is something that was not anticipated.
Are you suggesting there's a problem with Rule 70 to the extent that part of this issue seems to be that it took him 10 months to file his first petition because he didn't have the assistance of counsel? He didn't raise claims that were cognizable that would have warranted the court investigating the appointment of counsel.
I would love to suggest that there's a problem with Rule 70, Your Honor. I'm not sure this is the right place for it, but that rule is definitely like.
I.e. that there be appointment of counsel even before it's reviewed.
Correct, Your Honor. There are no further questions? Thank you.
Attorney Sibley?
May I also have my water?
You
too?
may.
Thank you, Your Honor.
I have cough drops if anybody needs them.
We have some as well. Thank you, Chief Justice Stanville, and may it please the court. The PCR court committed no clear error by summarily dismissing Mr. Armstrong's second petition for post-conviction review. Title 15, Section 2128-B1 plainly states that there is a one-year limitations period for filing a state petition for post-conviction review, and that failing to adhere to that filing deadline constitutes a waiver of grounds for relief. The face of Mr. Armstrong's petition affirmatively discloses, with no exception or explanation, that his petition failed to adhere to that filing deadline. Under Rule 70b-2, as has been pointed out by this court, the PCR court shall summarily dismiss under those circumstances. Additionally, this court should not consider the issue of equitable tolling because it has been raised for the first time on appeal. Thus, the proper foundation has not been laid. But even if this court were to consider it, there is no evidence in the record to conclude that equitable tolling applies to this petition. Happy to take questions.
Well, you said there's no evidence in the record that it applies, but there's no evidence in a record at all. I mean, there was never a hearing. Isn't that really kind of the issue that Mr. Armstrong is arguing for, is at least that let him try to make the case that equitable, it may not be successful at it, you know, but that he should be able to at least make the case?
Well, he had the opportunity to make the case. As Your Honor pointed out before, he could have submitted a letter with the petition and explained to the court, hey, I started this then, I couldn't have the notary come in, could have had the notary sign a letter saying, hey, yes, this is true. He had the opportunity, he didn't do it.
Or he could have said in his first petition, I'm handicapped because I don't have assistance of counsel in preparing this petition.
Correct. Now, whether, as Your Honor pointed out, that would be successful, likely not, as most of these petitions are filed without the assistance of counsel. It's only when cognizable grounds have been raised and it's assigned to the docket that the court appoints counsel.
Right, but there's some suggestion here that he had made a number of efforts over a period of time prior to filing that first petition to obtain some advice.
Again, there's no actual evidence in the record that that's what occurred. But
Is that a suggestion? There's a suggestion in the record.
Even if we assume that suggestion is correct, there's no explanation as to why he needed that information, and his first petition really belies the notion that he had to send all of those letters and try to get that information, because many of those issues he raised were raised in his prior appeals. He was aware of them, so there's really no explanation as to what he gained from that communication.
But doesn't that actually just point to the fact that without counsel, he's a little bit stymied on how he should raise the issues that he wants to raise?
I mean, not necessarily, Your Honor. As many of the federal circuit courts have pointed out, pro se status and quote-unquote ignorance of the law are not extraordinary circumstances. These are circumstances that apply to almost everybody in Mr. Armstrong's
What
position.
about if it is actions by the court itself that essentially stymied his efforts? In other words, I'm fairly concerned here that he files his first petition 4 weeks late, you know, with 2 months to spare, which should have been enough time. It takes us a month, and I'm not saying that that's extraordinary, but nonetheless takes a month before that is summarily dismissed. We know that some weeks later he files a motion to extend the time to appeal and is referencing a motion to reconsider that no one can seem to locate, and yet the judge has an order saying motion to reconsider denied. And so then the judge also says, well, I can't enlarge your time to appeal, which is actually not accurate. It feels like he got stymied by the court at every step, and I'm not sure what happened. Should there at least be a hearing to find out?
I do find the lack of docketing interesting, and I wish I could represent to the court that that's the first time I've come across something like that. But it seems implausible that he could have relied on the court's July order to his detriment, because it was issued over a month after his filing deadline had passed.
Well, and it was issued, that July order was issued after he had already filed a new petition, which also, as I say, could have even been considered an amended petition. And the second petition clearly does raise cognizable grounds, but for the time, et cetera. But my question really is, when we start talking about extraordinary circumstances, actions of the court are actions that are beyond his control.
The time crunch here, Your Honor, was created by Mr. Armstrong. He waited 10 months into his 12 months limitation period. It's just like the ordinary course of mail isn't an extraordinary circumstance. I would argue that a lot of the court operations aren't either.
Well, certainly the taking a few weeks, because it actually doesn't go straight to a trial judge to review. It goes to the Chief Justice, who then assigns it, et cetera. But I'm not saying that. I'm just saying all added up. Between the telling him he can't appeal that one, I can't give you more time to appeal, you can't, et cetera. It just does feel like he got a little stymied by the court.
Yeah, the court's
hard to
saying that
disagree.
couldn't it extend the time when the rule clearly states it can. I can understand where Your Honor is coming with that, but even if we're going to consider equitable tolling, we're going to have to start with diligence before we get to these
Right,
extraordinary.
but we don't have a record, is the point on the diligence.
Correct. I'm going with the suggestion
I
as to what
understand.
happened, but what we have in the record on the face of it is he waited 10 months into a 12-month limitation period to start the process.
So one would never have to reach equitable tolling at all if everybody filed it 1 month into the 12 months, right?
Well, it could make things easier, but that's not real. Probably not realistic.
As a realistic matter, the equitable tolling issue arises because people file later in the process.
Correct, Your Honor.
And so that in and of itself does not mean that there may not have been due diligence in this case, don't get me wrong.
Right,
But my question really is, shouldn't there at least be a factual record with findings to make these determinations?
Certainly, that would be preferable, hence this court's longstanding precedent that the foundation be laid in the trial court for appellate review, but the burden was on Mr. Armstrong to create that record. As Your Honors have pointed out with the questions, there were things he could have brought to the court's attention that would have maybe highlighted for the trial court, brought to the trial court's attention, and the trial court may have agreed with him and said, okay, I'll accept this, but Mr. Armstrong didn't do any of that.
Well, I may be missing something here, but Mr. Armstrong had two requests. He requested a motion for reconsideration, and he requested extra time to file an appeal. Now, I maintain, by looking at the docket record, that what the clerk did was docketed his letter requesting reconsideration. It didn't have attached to it a separate motion, at least as I've seen in the record. I think that was docketed as motion-other motion, and then beneath that docketed motion for allowance of extra time. I think the clerk docketed both of those entries on May, 2 weeks after the receipt of the April 10th, around April 24th or April 25th. The court acted on that motion for reconsideration within another week or two. The May 8th order was the denial of the motion. No, I'm sorry, that was the denial of the petition. Subsequently, had denied the motion for reconsideration. As for the extra time for appeal, he has an appeal. We're taking his case up here.
Regarding the second petition that he filed, not the first, but I believe his motions, the motion to reconsider that has disappeared, or at very least the letter and the motion to reconsider, I believe were both filed after the limitations period had expired, because it was in response to his receipt of the court's May order.
In an ideal
If I have my
world,
timeline correct.
in an ideal
You
world, he
are.
would
You
have
have-
filed his first petition, and it would have been rejected as not stating anything to which he's entitled PCR. He would have received that, immediately filed motion for reconsideration or a motion to procure counsel. That would have been acted on immediately. Counsel would have been appointed, and an amended petition would have been filed with cognizable PCR stuff. Ideally, that would have all happened in a period of like weeks, but of course it didn't. Bumped up against the deadlines there, and you can presumably understand the discomfort that some of the members of the court have expressed, saying, well, here's a guy who actually did start the process months ahead of time. Things happened in the meantime, so that some of the delays may have been the result of him, and others were totally beyond his control. And I guess I'll just ask, do you recognize, do you acknowledge the fact that there's some discomfort not knowing exactly the timeline of what happened and who was responsible for the delays of leaving him hanging out there without counsel?
I absolutely can understand the court's discomfort. I mean, I think it's why this court typically does not address issues for the first time on appeal without the record. But again, it was on Mr. Armstrong to bring that information to the trial court. He did not do that.
Well, and I'm looking at the times. The first one is dismissed on May 16th, and he receives it on May 25th. He knows his deadline is coming up, so it's 6/7. He's got to do something fast. He doesn't file his motion to reconsider, if we treat that as the letter, and his motion to enlarge until 6/20 and 6/21 past the deadline. So where is the extraordinary circumstance that we're to rely on for narrow equitable tolling?
My argument, Your Honor, is that there are no extraordinary circumstances here. He knew his deadline was coming, just as the court pointed out. Even if we take his suggestion that he started initiating the paperwork on June 2nd, he waited nearly a week and within 5 days of the deadline, and then waits even several more weeks to even address the first petition, as Your Honor pointed out, filing those motions after the expiration of the date. Those aren't extraordinary circumstances.
And when we look at the narrow grounds that the federal courts apply for equitable tolling, it's usually something that's very affirmative. Somebody lies to the prisoner. I mean, can you identify any situation where it's a delay? I don't have a lawyer. I can't get to a library. It's taking a long time to get a notary. Do these fall into conditions out of the control of the prisoner that have been relied on as a basis for equitable tolling?
In the circumstances of this case, Your Honor, I would say yes, those fall into the category of things inherent with custody. He knew that a notary was not readily available. You can look at the dates on his first petition as to when he signed it and when it was notarized. He knew there would be a delay, and he delayed further. Now, there could be a circumstance where either trial counsel or a court, when something's filed, makes a misrepresentation that impacts what an individual does. There potentially could be a circumstance in custody that would qualify, which is why, when we're talking about equitable tolling, it's done on a case-by-case examination. In what we have in this case, I would argue, is neither diligence and not extraordinary circumstances.
We also have a statute that tells us when waiver occurs. And it says you're supposed to raise all grounds in a single PCR, and if you don't, there's a waiver, unless the Constitution requires or the court determines that the ground couldn't reasonably have been raised in an earlier petition. Is there a reason why ineffectiveness of counsel or prosecutorial misconduct couldn't have been raised in the first petition?
I believe they were, Your Honor. I think it's ground 2 of the first petition where he discusses prosecutorial misconduct and inducements. But again, those were all issues that either were...
But he didn't allege ineffective assistance in the first petition.
Correct. When I look at the two petitions side by side, they're actually pretty similar if you look at what he writes as the factual basis, but he just writes ineffective assistance of counsel. Ground 3 of the second petition, I think, is a cognizable ground because it's alleging ineffective assistance. I believe in his first appeal, not raising the sufficiency of the evidence argument, and sufficiency of the evidence was not raised. I believe that's this
So I think
point.
Justice Connor's question is, are you able to identify any reason why he could not have simply said ineffective assistance of counsel in the first petition?
I am not, Your Honor.
Did I get that right?
Yes.
I apologize for misunderstanding your question, Your Honor.
Thank you. And Ms. King, isn't that really the challenge here? Prisoners file these all the time, and they know the magic words are ineffective assistance of counsel.
I think that's true under ordinary circumstances, Your Honor. But if you look at the case of Hudson, it talks about limited education as a factor. In this case, at least in his memorandum to this court, Mr. Armstrong has suggested that he has low reading capabilities. And so I would suggest to you that that's one of the factors that should be considered when determining whether or not he was able to.
It could be, but the reality is that his filings in the trial court as well as to this court, frankly, are more articulate than many we receive.
Fair enough on that front, Your Honor. To address Justice Connor's earlier question about whether or not there are cases on point, I would suggest to this court, in addition to the Hudson case that I just noted, the Ramos case, which I spoke of earlier, does quite a very good job of analyzing due diligence as well as extraordinary circumstances. And in that case, the court said that there are a number of factors that did lead the court to believe that Mr. Ramos was exercising due diligence, including that he was in state custody, he had no attorney, he had opposed motions, and for years he had been trying to exercise his rights. And I would suggest to you that that's the same here for Mr. Armstrong. He took a number of steps. He didn't sit around doing nothing, and then one fine day on June 21st, he tried to file a motion. He took a lot of steps along the way to try to exercise his rights and was stymied by the courts and their ineffectiveness. So given the torturous nature of this case, I would suggest that the only remedy is to remand this case, appoint counsel to Mr. Armstrong so that we can perfect a good record.
So next time you may have to reserve 2 minutes for rebuttal.
Indeed, I'm still learning, Your Honor.
Thank you, counsel. Thank you, as always. And we will take the matter under advisement and issue a written decision in due course. Thank you.